major breaking news. This is fantastic and huge news out of the United States Supreme Court. It is just broken that the Supreme Court has taken two Second Amendment related cases. They're not specific to the Second Amendment, but they relate to the Second Amendment in a huge way. Specifically, as I predicted in October of 2022, the U.S. Supreme Court has granted cert to whether or not the ATF's bump stock ban in the Cargill case out of the Fifth Circuit, whether or not that is constitutional. It's not, by the way. And number two, the NRA Case versus Vulu case, which deals with whether or not governments such as Governor Andrew Cuomo of New York State can basically mess around with gun companies and violate the First Amendment or not. We're going to talk all about this when we get back. This is huge, great news for the Second Amendment community. We'll talk about it in 1 second. Hey folks, I'm Mark Smith, host of the Four Box Diner, proud American gun owner, constitutional attorney, member of the U.S. Supreme Court Bar, and author of Disarm: What the Ukraine War Teaches Americans, and of course Israelis, about the right to bear arms. All right, major news, U.S. Supreme Court has just granted cert, which means they're going to hear on the merits two cases, a bump stock case, whether or not the ATF's bump stock ban is constitutional and legal, whether or not the ATF had the authority under congressional enabling legislation to do what they're going to do. And yes, indeed, it's going to matter big time for the frame and receiver and the related issues. We'll get to that in 1 second. The second issue is the NRA versus Vulu case. As you recall, in 2018, after Parkland, there was an attempt by New York State to punish the NRA in various ways by going after them financially, basically because New York State did not like the NRA's political positions in support of the Second Amendment. And as a consequence, there was a whole host of issues using allegedly New York State's regulators to threaten business activities associated with the NRA in the state of New York, and ultimately it hurt the NRA dramatically, according to the allegations in the court complaints and the court documents. Again, major win. We'll see what happens when the Supreme Court. But let's do one thing at a time. Let's start off with the bump stock case, then we'll turn to the NRA in 1 second. To begin with, as you know, the reason why the bump stock ban, which was instituted in the era of Donald Trump, is true. This never should have withstood any court scrutiny. The argument is that the bump stock, which is a piece of plastic that attaches to a semi-automatic firearm, and as you know, if you hold it in a particular way, it allows the semi-automatic firearm to essentially function as an automatic weapon, in the sense that you only hold the trigger down, I believe. You hold the trigger back and it just keeps firing until the magazine or the gun expends all of its ammunition, or until you let go. Now, of course, this is the sort of thing that you can do with a bump stock, which is this piece of plastic, but a lot of people can do it, with their belts, loops. I've never tried to do it. There's a lot, people are much better on guns than I am specifically. I'm not a great gun guy compared to a lot of you guys out there on the internet. I'm really a gun law Second Amendment guy, but you guys know how to do all that fancy stuff. I'm not that competent to do that. So with that said, here's the issue. The Trump administration, after the Parkland school shooting in February of 2018, which is an example of government incompetence up and down the line, but back then I think the Second Amendment community was not as sophisticated as it is today in terms of understanding the reality of the ground, that most of these shootings involve government incompetency, and thus we have to defend ourselves as being our own first responders, because the government simply will not do it. So in light of that, there was discussion of whether or not there would be legislation, and two interesting things arose out of that February 2018 Parkland situation. And mind you, I know all about this because I wrote the book called #Duped, How the Anti-Gun Lobby Exploits the Parkland School Shooting. So if anyone's familiar with the details of what arose from that, it is the Four Boxes Diner, because I wrote the book on it. And I followed it up with First They Came for the Gun Owners. So with that said, here's the two things arose out of that February 2018 unfortunate situation where the government failed to protect the kids in the Parkland High School. Okay. First thing was, there was pressure to do something, whatever that means, about guns. The right answer, of course, is to arm the teachers and administrators, but there was a debate at the time about doing something, and there was discussion whether or not Congress would roll over, because Republicans historically are squishy squishes like that moron John Cornyn in Texas, who negotiated the bipartisan anti-gun bill in the summer of 2022, literally as we are victorious in the Supreme Court in NYSERPA versus Bruin. But no one knows how to lose a case or lose a situation when we should win, then, some Republicans like John Cornyn of Texas, I hope you people in Texas remember that going forward. Anyway, with that said, the first thing that came out of this attempt to do something, Congress did not act. So Trump basically, through the ATF, directed them to ban bump stocks, which is really kind of a range toy. I don't support banning bump stocks. That's terrible. 150% against it. But of all the things that we could give up at the time, if that's what we had to give up, bump stocks was a minor price to pay for making sure that we did not have stupid actions in Congress or anything else. So I do understand sometimes that can happen, although I don't like it at all. With that said, that was a political decision that was made in the summer of 2018 by the Trump administration, rightly or wrongly. And as a consequence, there was a series of litigations between then and now about whether or not the ATF had the authority. As you know, the ATF is part of the executive branch, which means they have to get their authority from Congress. And how does that work? Specifically, Congress passes a law, a statute, often referred to as an enabling legislation. And this legislation gives, for example, the ATF or another regulatory agency within the executive branch, which is controlled, of course, by the President of the United States. It gives the authority, the legal authority, their congressional or statutory authority to, in this case, the ATF to do certain things. So specifically what happened here is that the ATF took the position that the bump stocks converted semi-automatic firearms into machine guns, and therefore bump stocks were, for all intents and purposes, were indeed machine guns under the federal statutory definition of machine guns. This obviously was, to say the least, a stretch. Specifically, the federal government has argued and has tried to stretch the statutory definition of a machine gun to somehow sweep within it the concept or the notion or these things called bump stocks. Now, this case should have been a deadlock loser against the ATF from the start. ATF really had no legal authority to do this, but that's what they did. And I'm happy to report that Michael Cargill down there in Texas brought a lawsuit and was the first case of all the bump stock cases to actually get to a final judgment. Remember, many people criticized me when the bump stock cases were denied cert a couple years ago, and I said, and I'll put a link to my video down below so you can see I'm always ahead. I'm ahead. And to prove that I'm always ahead of the game, or usually ahead of the game, I put a link to my October 2022, that's 2022, not 2023, October 2022 video where I specifically said that do not get depressed about the bump stock situation because the Supreme Court is going to take this case. They are going to take, of all the different cases out there, they will take the Michael Cargill case out of the Fifth Circuit because that's going to get to final judgment first. And when the Supreme Court takes that bump stock case out of the Fifth Circuit, they are going to whack the ATF. And in the process of whacking the ATF, they are going to cut back dramatically on the authority of ATF to make stuff up under statutory law. And yes, for those of you asking the obvious question, this 100% will serve as a precedent to cut back on their ability to mess around with pistol braces, weapon parts kits, unfinished frames and receivers, and so on. This is what's going to happen. And if you see what's happening here, and this is what I predicted. I said, remember, there's a process. The law in America goes step by step, case by case. There's a process here. So if you look at what's going to happen this term, which started in October 2023, will end in June 2024, what's going to happen? Exactly what I predicted. Two things are going to come in and crush the ATF. The first thing that's going to happen is, as you know, the Supreme Court has already granted a cert in a case called Loper Bright dealing with fishing vessels. And the question is whether or not in that case, whether or not the Chevron doctrine, whether or not that's good law. Now, for those of you out there that support the Second Amendment, for those of you out there that support limited government and want less federal government instead of more federal government, you 150% want to get rid of the Chevron doctrine. The Chevron doctrine says that if there's any debate or ambiguity about whether or not a regulatory agency like the ATF has authority under its statutory authority given to it by Congress, then the presumption is that the ATF or the regulator's interpretation of the law wins. Federal courts are supposed to defer. That's right. Federal courts are supposed to defer to the agency. So in dealing with the ATF, federal courts are supposed to defer to ATF interpretations and applications of rules and regulations. This, of course, allows the actual regulators, the executive branch regulators under the president, to expand their jurisdiction and powers and authority in a way they should not be allowed to do so. Now, if you get rid of the Chevron doctrine, which is going to happen this term, it's basically going to say to the federal courts, they get to treat ATFs of the world, the regulatory agencies of the world, as any other litigation begin. They're not going to let the ATFs of the world dictate their powers, which of course is absurd, because we would never let, for example, federal prosecutors and U.S. attorneys' offices to define statutes that they're prosecuting somebody in court. Judges always make that decision. So too should it be the case with things like ATF regulations. So first thing that's going to happen is the Chevron doctrine in this term is going to go by the wayside. This is extremely good news for freedom, extremely bad news for government regulators, and extremely bad news for the ATF. That's the first shoe that's going to drop. The second shoe that's going to drop right on top of the ATF's head is exactly what I predicted, this bump stock case. Remember, the pistol brace case, the stabilizing brace cases, the frame and receiver issues, the weapon part, all these regulations involving these other things, these are still relatively new. Now, I think these things should have been stayed, but we've talked about that in other videos. But the bottom line is this, that the Supreme Court is letting those cases go through the normal process until there's a final judgment, in those other cases. But the one thing that's already happened is there are now final judgments in these bump stock cases, and the Supreme Court, as I predicted, once you get to a final judgment, was going to take one of them, and indeed they took the Cargill case, which I think is the first case that got to a final judgment, out of the Fifth Circuit. The Fifth Circuit, of course, covers Louisiana, Texas, and that part of the country down there. The good news is this is very exciting that this is going to happen. The other thing that's going to happen here is, again, the second shoe that's going to drop on the ATF head is the Supreme Court is almost certainly going to say that the ATF lacks the authority to define bump stocks as machine guns. That will be a very long 50-page opinion to explain how the ATF overreached its authority. It's going to have some very good language in there. And yes, indeed, that language will be subsequently used in cases involving the pistol brace rules, the gun kits, the unfinished frames and receivers, and so on. So it will all be an excellent term, I predict, that will rein in the power and the authority of the ATF. Remember, power and authority are not the same. Power means I have control over something. Authority means I have the legal authority to act. A kidnapper may have power over the hostage, but that doesn't mean he has the authority to act over the hostage. Right now, the ATF has been basically using a bunch of powers. In my opinion, they lack the legal authority to exercise those powers, and the Supreme Court is about to spank them big time. Exactly as I predicted in the year of our Lord, October 2022. I'll put a link to it down below so you can see that when I make my predictions, guess what? They frequently come true, especially when it comes to the Supreme Court and our gun rights. Now, the other major issue here that also is hugely important to the Second Amendment. In my book, First They Came for the Gun Owners, I lay out in extreme detail, as you know, exactly how the anti-gunners intend to destroy our right to keep and bear arms. One of the ways they intend to do that is by government over-regulation at the state level, specifically to find ways to punish the gun industry, to punish gun advocates, to basically, to some degree, do what they're doing to President Trump. Like, you can debate good and bad of Trump. We don't need to get into that. But the point is, whatever you think about it is, there's no doubt that they're treating the Department of Justice, in my opinion, is treating President Trump differently and his staff differently and people that support Trump differently and the January 6 people differently than they treat, let's say, lots of other people on the left, like the rioters of 2020. Again, I'm not here to debate that. The point is there clearly seems to be governmental decisions that are punishing people on one part of the spectrum of politics and not on the other. The reason why that touches fingers with this case involving the NRA, the National Rifle Association, which I do, applaud and support, and I hope they win this case. The NRA versus Vulu case, this is a big deal because what happened in the NRA case, and this also arose from Parkland 2018. Remember, the bump stock ban arose out of Parkland February 2018. The other thing that arose out of Parkland 2018 was New York State, if you recall, really looked hard at the NRA and tried to find ways to punish the NRA in various ways. The NRA, rightly or wrongly, was incorporated in the state of New York, and I don't know where they're technically incorporated now, but they at the time were incorporated in New York, which meant that the New York Attorney General had legal authority to investigate the NRA as an organization that's in New York. That's how they had the jurisdictional hook. Okay, with that said, there was a whole bunch of statements made to, as I understand, to various business partners that were doing business or conducting work with the NRA, and there were statements made by the state of New York, which of course is a government agency. The reason why that's important is under the First Amendment, you have a right to free speech. That includes the right to seek redress from the government, a right to political association, a right to petition the government for redress, and to speak your mind, especially on political issues. And if the government steps up and starts to punish you, so for example, let's say they punish the NRA for liking guns and supporting the Second Amendment, but at the same time they reward organizations for hating the Second Amendment and supporting gun control, that is basically not a content neutral regulation. That is not a content neutral action by government. That is basically government supporting one political viewpoint over another and punishing the person that has a viewpoint they disagree with. So here's what's been granted cert. The Supreme Court granted cert on the following question involving the NRA, because the NRA claims they lost a lot of money and were punished by the state of New York. And I'm guessing that's all true, by the way. We'll see what happens. But the question presented to the Supreme Court involving the NRA case is this, quote, does the First Amendment allow a government regulator to threaten regulated entities with adverse regulatory actions if they do business with a controversial speaker as a consequence of A, the government's own hostility to the speaker's viewpoint, or B, a perceived general backlash against the speaker's advocacy? So basically, according to this question presented, is New York allowed to punish the NRA in terms of regulations and how they treated the NRA versus other organizations because allegedly the state government targeted the NRA because they did not like the NRA's political activities or political viewpoint or political support, and therefore New York used their regulatory agencies to punish the NRA in the state of New York. And the question presented is, does the First Amendment allow this, or did the state of New York violate the First Amendment rights of the NRA? I have a feeling this is going to go very, very badly for the state of New York. But again, only time will tell. But the bottom line is, I think we should be very happy that the bump stock ban is likely going to get tossed out into the trash heap of history, and the consequence of that will be very positive in terms of shrinking the authority of ATF in all sorts of ways. And I think there's an excellent chance that the NRA is going to prevail. And I think this is very good news for us because, in my opinion, what it really teaches is this, that the U.S. Supreme Court is sensitive and aware of this governmental hostility to gun rights and gun advocates and gun supporters in the gun industry. And I think the fact that they took this NRA versus Vulu case involving the First Amendment and gun advocacy groups, specifically the NRA, of course, I think this is a very good sign that the Supreme Court is on top of what's going on with the Second Amendment right to keep and bear arms in our country right now. And of course, this is on top of the Rahimi case and possibly the Range case coming down the pike. So this could be a very big deal for our right to keep and bear arms. And I, of course, here at the Four Boxes Diner, will keep you abreast of all the developments. And again, hope you learned something here today at the Four Boxes Diner. If you haven't subscribed, please do so. Don't forget to follow me on X at Four Boxes Diner. And again, we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.